Surname is Vobi. I appear with Mrs. Makangela for the applicant. In the matter brought by Ravens, we are cited as the respondent in the matter. We appear for I think it's the fourth, if not fifth, respondents. That's how we are cited in that matter.
I see even in their founding papers they have made that error of referring to Amabarara what fifth respondent as Sinenkani.
Yes, ma'am.
But I'm sure it's something that is sort out every process.
Thank you, ma'am.
Case number 3301, I appeal for the applicant.
Yes, thank you.
Please record my notes. In case number 3011, I appear on behalf of the first to fourth respondents. And in respect of the Ravens case, my lord, I appear for the first, second, and third respondents. My lord, I appear together with my attorney, Mr. Bilalazi. I did not mention this to my lord in chambers, but I'm instructed to deal with the preliminary issues in respect of the application raised by the clients. And should we get the Mr. Bilalazi will address the issue on the merits of the Sinenkani application, and I will deal with the merits of the other applications.
I'm sorry, your name again?
Mabaso.
Mr. Mabaso.
S.R.
Thank you, Mr.
And lastly, my lord, for ease of reference, especially the parties, in our address to the chief, we'll just refer to our clients as Safa or the Safa respondents, just to make it easy to follow.
That's fine. Thank you,
As it is, my lord, my initials is M.A. My surname is Lamini with an H.
As in D-H-A.
D-H-L. Yes, D-H-L-A-M-I. My lord, obviously we are not reflected on the papers. We would be making an application to intervene in this matter. I am acting for Thames Football Club. I think we've given you a smaller one.
Yes, I'll proceed to that.
That's a pretty small one. So I think we will then refer that to the other issues.
Thank you.
And we are not really going to participate in the second case, but we are participating in 3011 of 2025 as a president.
May it please the court, my lord, I appear for the party to intervene in case number 3011 of 2025. For the record, I'm Mhlanti from the Johannesburg Bar and the Bishop Bar. I'm instructed by BDP attorneys. We are not participating in the other matter. It's only case number 3011.
Just for the record, Mr. Mhlanti, you will name your client or those who will do that.
Yes, my lord. That is Kakamas Juventus Football Club, my lord. Just for this.
Gentlemen, a housekeeping issue. Those who were here on the previous occasion, we had, I'm sorry to say, Kiwa Media. There was an application by Kiwa Media to broadcast these proceedings. It was allowed in those proceedings. The gentleman from Kiwa Media, I'm sure he laboring under the misapprehension that this is a continuation of those media proceedings. He may have brought an application, but I'm not aware of it. We all see that here is obviously applying to broadcast these proceedings. may I get an indication from all the parties if anyone opposes the application from Kiwa Media broadcast these proceedings? Mr. Bobby, you started.
Sinenkani has no issues that he may broadcast the proceedings.
Mr. Scotty?
No objections.
Mr. Mabasi?
Your Worship, we just wondering if this application was brought on an urgent basis, but we have no objection.
No. Thank you. Mr. Zamini?
No objection, madam. No objection.
Thank you. Mr. Mklanti?
No objection, my lord.
Kiwa Media will consequently allow us proceedings and as discussed in the chambers. There are two applications to intervene. There is an application by Thames Football Club. We will start with that application to intervene. Mr. Flamini, over to you.
As it please, my lord, we have served a bundle and it says intervening party index.
Yes.
There's a notice in terms of return, but we're saying that the notice must be read in terms of those 14 of the uniform rules and the notice of intention to oppose. My lord, I assume that you have read the papers. I'm not going to labor you with a number of issues, but we have also prepared, I think, in that we've given you another smaller bundle which relates to our heads of argument. Yes. Yes. So, my lord, I just want to take you to the heads of argument in order for us to expedite the process. The leading case on non-joinder, it's found at it's paragraph 15 of that of those heads of argument, 16 to be exact. We're saying that the leading matter in regard to non-joinder is the matter of ABSA versus NLD, nomina oblique. There's a citation there. The test to be applied is to determine if the joinder will safeguard the interest of the parties who have not been cited and to ensure that their rights are considered. As it is, my lord, today at 15 hours, the playoffs are at the semi-final stage in Gauteng. So we obviously, our client have interest and it's substantial in terms of anything that we expect at this particular honorable court. We're saying that we are making an application to join, and we've shown that substantially we have interest. The interest, obviously, we will show you at a later stage, but it relates to our client playing in the professional league next year, which would amount to the status worth around about 10 million as compared to now, which is around 600,000. So we've got substantial interest in the matter. We're not going to labor you on the other aspect, but we're saying that we're entitled to join the proceedings.
As I understand it, paying the national playoffs.
Yes. And as it is, as I speak to you now, there's only 2 games that are left, meaning the semi-final and the finals, and they're taking place this afternoon. Yes, so those are submissions, my lord. We're not going to labor you in terms of any other aspects. We have just proven that we've got substantial interest in the request and humbly request that we be joined in these proceedings.
Yes, thank you. Mr. Mklati or Kakamas United.
May it please the court, my lord. This is an application by the Kakamas Juventus Football Club for leave to intervene in the proceedings. My Lord, I'm also not going to bore you with the...
I'm sorry, you will have to say up front, intervene as what? In which application? Because we're dealing with two applications. Mr. Dlamini, your colleague, has been clear that Kane, which is drawing as the seventh respondent in case number 811 of 2025.
Yeah. This application is in respect of the matter whose case number is 3011 of 2025. And it's a application for leave to intervene as a second applicant, the first applicant being Sinenkani Football Club. My Lord, the applicant ought to show direct and substantial interest in the matter at hand. So that was held in the Constitutional Court in the case of SA riding for the Disabled Association versus the Regional Land Claims Commissioner. Paragraph 9 of that Constitutional Court judgment, where it was held that it is now settled that an applicant for intervention must meet the direct and substantial interest test in order to succeed. What constitutes a direct and substantial interest is the legal interest in the subject matter of the case, which could be prejudicially affected by the order of the court. This means that the applicant must show that it has a right adversely affected or likely to be affected by the order sought.
And what's the citation for that case?
SA writing for the Disabled Association versus Regional Land Claims Commissioner and others. It's 2017, Volume 5, SA1 Constitutional Court. My Lord, that will be found in paragraph 9 of that judgment. My Lord, the applicant on its founding papers avers that they had played games that were played on the 1st of July, that is being on Tuesday. They are the Northern Cape winners. They are on the Group C. They were supposed, in that group it's Limpopo, it's Northwest and Northern Cape. Safa having issued the fixtures, the groups that are supposed to play and divided the 9 provinces into 3 groups, that is Group A, Group B and Group C. And Group C is where the applicant, being Kakamas Juventus, is found. The applicant's point is that, my Lord, in that Group C, on the 1st of July, having played and lost 2-1 in that game, they were then told by way of a letter dated the 1st of July, that is the same day they were playing the games, which letter in fact was communicated to them the following day, being the 2nd. It's only then that they were aware that they are no longer going to participate any further. The problem with that, my Lord, is that had that been communicated in advance, that because Limpopo, there are disputes, which Limpopo forms part of their group, which then leaves them in their group of 3, with only 2, that is Northwest and Northern Cape, they will have advised as to how this matter should be handled. As it stands now, my Lord, the other groups or the other teams in other groups play twice, which then would either entitle one to proceed to another level. But in this case, the complaint is that there's only one lead. So what the applicant seeks is just one more chance, another chance to play, as that will be a determining factor as whether they proceed to the next level or not. That's in terms of the promotion. So
let's deal with that, Mr. Mhlanti, when we deal with the merits, if we get that far. It's enough that they are one of the 7 participants that have taken part in the national playoffs. I think on that basis alone, it's sufficient to decide it on that.
May I make just one more submission? The matter had been opposed, the application has been opposed by Safa. But I have been advised that that is no longer the position. Perhaps the colleagues may confirm that.
They are here, they speak for themselves.
Thank
Thank you, Mr. We will start with those who are involved in case number 3011 of 2025. Mr. Vobi for Sinenkani. What is your Sinenkani's attitude to the application for joining, for the record?
Note, our position is clear. We cannot preclude any party that wants to participate in the proceedings to participate. The question of whether the participation has merits or not, that will be determined when we deal with the merits of the matter. So on our side, they can come and join. We have no issues as a competitor.
Hold no ones on all of the parties that seek to intervene as a result, or to that effect. We did not even oppose any of the applications, so it's not should be hold on that.
Thank you. Mr. Mabaso, the Safa respondent.
My Lord, whilst we say Kakamas is not entitled to the ultimate relief sought, we will not be persisting with our opposition to the joint on the matter.
Yes, I'll just pronounce the ruling without any reasons provided. The ruling is that on case number 3011 of 2025, Kakamas Juventus is joined as the second applicant, and Thames Football Club is joined as the 7th respondent in the same case 3011 of 2025.
As it is, Scott, please.
I must just state, I make that ruling without having determined the point in limine that this court has no jurisdiction. The ruling is made so that all the parties who wish to participate may participate in these proceedings. The next point that needs to be determined before we deal with the merits is the point in limine about whether or not this court has jurisdiction. Mr. Mabaso. It's you raising a point. I'll give you an opportunity to be heard first.
As it is in the court, my lord. My lord, as a point of departure, perhaps it's appropriate for me to begin with identifying what this matter is truly about. On the papers, there are two main forms of relief sought by the applicants. And by the applicants, my lord, just for ease of reference, I mean the applicants collectively in both applications. And this point addresses both applications. Both parties, my lord, seek two forms of relief. On the one hand, they seek a review, in order to review and set aside a decision taken by my client on the 1st of July 2025. I will refer to that as the review relief. On the other hand,
If they review the decision of the competitions committee,
the decision of the competitions committee, which, my lord, in one of the affidavits, we say that in effect then it becomes a decision of Safa.
yeah, no, I just wanted us to identify
Yes, ma'am.
the actual decision.
Yes, ma'am. I was just pointing out that in the affidavits, flowing from that, we make the point that therefore it is a decision of Safa. So that's the first form of relief, and we say that is a primary relief sought by the parties. Flowing from the primary relief, my lord, is interdictory relief. Chief amongst to interdict the continuation of the ongoing national playoffs, which are happening in Gauteng, in Pretoria. On that note, my lord, I confirm that the games are still ongoing and the semi-finals are scheduled to play today, and the final match is scheduled to play tomorrow, on Sunday. So those are the two main forms of relief. First, you get the review, and flowing from the review is the interdictory relief. In other words, without the review, the interdict, that relief would not exist. It's important, my lord, for us to understand the basis of the application. Therefore, the basis of the application is, as my lord correctly pointed out, the decision of the competitions committee. On that basis, my lord, we say this application is a substantive standalone application. We make this point that it's a substantive standalone application because it appears from the founding papers of the applicants that there may be some sort of confusion about the nature of this application. It appears from the affidavits, they seem to suggest that this application is in some way an interlocutory or an application flowing from the previous litigation between the parties. That, my lord, is incorrect. This is a substantive standalone application. It's not an interlocutory. It's not an application to enforce compliance with your lordship's previous orders issued this week. That's not what they want. They are not before court claiming that we are in contempt of previous orders. It's a new application based on the decision that was made on the 1st of July. Therefore, the cause of action for the review relief is the decision. The cause of action is the decision, and flowing from that, then they want to review and the ancillary relief. My lord, on the facts, there are certain undeniable on the papers, there are certain undeniable facts. I'll put it that way. The first is that the officers of Safa, being the first applicant, are in Gauteng, in Nasrec, in Johannesburg. The second undeniable point, my lord, is that the impugned decision was also taken in Johannesburg. The third undeniable point was also taken in Johannesburg.